In today's workplace, things are evolving quickly and complexity is the norm, but clarity is a choice. This Week at Work is where leaders get practical solutions and timely insights for today's toughest workplace challenges.
Hello, everyone. I'm Phil Brandt, President and CEO of AAIM Employers Association, and welcome back to another episode of This Week at Work. Today, we're discussing a wage and hour decision that could have a significant impact on employers across the country. On June 3rd, 2026, the Third Circuit Court of Appeals issued a major ruling involving so-called gap time claims under the Fair Labor Standards Act. Joining me, as always, is Burt Garland, shareholder with Ogletree Deakin. He's also my co-host and one of the nation's leading employment law attorneys. Burt, welcome. How are you doing today?
I'm doing great, Phil. How are you today?
I'm doing very good. I'm getting super excited for the month of July. I'm
What?
looking forward to the 4th of July, which is my favorite holiday, and we're almost there. I'm doing great. Yourself?
I'm doing great. I'm still waiting for that 4th of July boating invitation from you, Phil. I never seem to
Oh,
get that one.
well, I don't know if you really want to have that experience with me. And sometimes it's better not to have your work colleagues, see you with your shirt off. So that's okay when you're out on the boat. How about lawyer on the clock today? You want to do that?
Sure, I've got some good topics to cover.
All right, ready? Bert, lawyer, you're up. You're on the clock.
All right, thanks, Phil. So the first one, I know we've talked about these on past shows, but we are going to delve deeper into one of these topics, I think, on our next program. But some of the most prominent developments in the area of labor and employment law in the last few weeks is the Department of Justice has now questioned what's called the disparate impact theory of liability. And the Department of Justice specifically issued a legal opinion stating that the EEOC's current interpretation of disparate impact under Title VII is unconstitutional. So while it does not immediately change the law, it definitely signals a major shift away from prior enforcement standards. Now, of course, Phil, you're probably wondering to yourself, and I know you know the answer, but what is disparate impact? Disparate impact is a theory of liability that people have pursued over the last several decades, which basically goes like this. The employer has what's considered to be a facially neutral policy. It might be a testing requirement, for example. And you may think of, like, let's take the firefighting sector, and that may have a facially neutral policy that you have to be able to climb a ladder within so many seconds. And what that facially neutral policy may end up doing is it may end up filtering out female employees because they may not have the same physical abilities as the male employees. And so they cannot climb the ladder as quickly as the men. And so, again, it's a facially neutral policy. It appears to be neutral. It applies across everybody. But what it's doing is it has a disparate impact on females over males and impacts them more severely, filters them out at a higher rate. And so in order to get around that theory of liability, typically the employer would have to prove that it is a bona fide occupational requirement, that there's a reason for having the requirement that people climb a ladder within a certain amount of time, or people be able to climb ladders carrying a certain amount of weight, either up or down the ladder. You can also think of it in any type of setting as a testing requirement. Testing requirements are often ones that end up having disparate impact. You can also think of it in terms of like the criminal conviction question in job settings, that it's been shown that while it's facially neutral, it applies to everyone. It's been shown to have a disparate impact on Blacks and Hispanics. Well, the Trump administration has sought to do away with this disparate impact theory of liability, and the Department of Justice's actions just in the last week or so, last couple of weeks, really takes a step forward toward doing away with that disparate impact theory of liability. So one for all of us to keep our eyes on.
Yeah, absolutely. That's a great update. Thank you for that.
Sure.
Yeah.
The other one I want to talk about, Phil, is, and this is the one we'll delve into more deeply because I know we've been getting a lot of questions about it since I raised it on the last program. The EEOC just in the last couple weeks has issued its new national enforcement plan, which replaced its prior strategic plan that was in effect. And the prior strategic plan prioritized investigating diversity, equity, and inclusion efforts or prioritize advancing diversity, equity, and inclusion efforts under this new strategic national enforcement plan. The EEOC is prioritizing the investigation into diversity, equity, and inclusion efforts, also defending women's rights to single-sex spaces, think bathrooms and locker rooms, and protecting workers from national origin discrimination. And so I think on our next program, Phil, we're going to delve much deeper into the EEOC's national enforcement plan, this new national enforcement plan, and what it can mean for employers.
Yeah. Yeah. This, I know just from talking in broad sense with many of our members, there's a lot of uneasiness around this, and there seems to be this sentiment of we're moving in the wrong direction versus the right direction being more inclusive, that this is creating more of a line of separation. I know that's not how you see it nor how I see it. So I think that can be a really good conversation to just dig into what is really the intent and what's trying to be what's happening to be fair to everyone and non-discriminatory in those ways. But there's a lot of sentiment around this and unhappiness around some of these decisions with one particular group of people, and then I know there's another group of people that feel really pretty solid and happy about this. So it just is a little bit of divide out there right now. Yeah.
Yeah, I would say there's actually quite a large divide on this out there. And it all has to do with the efforts and the time and investment the companies have made in DE&I programs over the last, 5, 8 years or so, and pursuing all of those efforts
Yeah.
and sort of for lack of a better term, the marketing behind it, the money behind it.
Sure.
And just to see all of this being undone by this current administration in those issues, under the guise of diversity, equity, and inclusion, unfortunately, when you make efforts to specifically include people, you necessarily, it's not the goal of it, but you necessarily might be excluding people
Yeah.
on those grounds, on those very grounds that you're now supposedly including people. You also can't turn around then and exclude people. So it's a very difficult issue to navigate, and it gets back to that pendulum swinging that we often talk about on the program.
For sure. That's going to be a good one. Tune in and learn more. And we hope to bring some good insight into that and fairness and how we look at it. Burt, let's just talk about, if we can, what's going on with the Fair Labor Standards ruling that we kind of kicked the program off with, and this thing called gap hours. First, just start with why is this case important for people to hear and know about today?
Well, so this particular case that we're talking about out of the Third Circuit involved nearly 6,000
Hmm.
employees and resulted in a damages award that exceeded $35 million. We've talked often on the program that class and collective action in the wage and hour area is the number one source of employment law claims in class and collective actions. These actions related to the Fair Labor Standards Act, and
Hmm.
so employers definitely need to be aware of this. This case addressed a theory of liability that the Department of Labor has aggressively pursued for years. In fact, they've been pursuing this theory of liability for so long that I think many of us, even in the employment law, sector have just sort of taken it as a foregone conclusion that the Department of Labor was right on this. And what the
Okay.
court basically said here is that a certain category of damages that the DOL has relied on isn't actually recognized under the Fair Labor Standards Act any longer.
So now let's just help our listeners, and you and I have talked about it on our program. It's why listening frequently is helpful. The the court, not necessarily the Department of Labor has, or the Fair Labor Standards, I guess it would be the DOL. The court made this decision. Is that related to the Chevron process?
By and large, yes. When we've talked about this so many times on the program, that under the case of Looper Bright, that the Supreme Court decided within the last year or two, that the Supreme Court said that the administrative agencies are no longer entitled to deference in the court system on issues really of first impression. The court is the one that should decide this, not the administrative agencies. And so I think
that's why we have kind of a difference of opinion. So we've been following the rules under the administrative agency, and now we have a court saying, we don't see it that way.
That's right. And so I think that's really what's going on here. And just so we don't keep our listeners in too much suspense, the issue that we're dealing with here specifically, or the Third Circuit dealt with, is something called gap time under the Fair Labor Standards Act.
All right, well, go on and tell us, what is gap time? Not everyone will know that phrase.
Yeah, so gap time is it basically refers to hours worked that an employee claims were unpaid. But very importantly, those hours do not create a minimum wage violation and do not necessarily qualify as overtime hours. So it's a situation where somebody's actually working longer than what the time clock shows, but even when they work those longer hours, it's not taking them below minimum wage. And so it doesn't necessarily create a minimum wage violation, or I would actually say it doesn't create a minimum wage violation. And this time does not necessarily qualify as overtime hours. And so under the Fair Labor Standards Act and the Department of Labor, for really years, and I'd probably even say decades, we had all kind of just presumed that if somebody was working off the clock, that they needed to be paid for those off the clock hours, and that those off the clock hours could qualify as overtime hours. And the Third Circuit has really called this into question.
Okay.
And I could provide an example, Phil, if you want.
No, yeah, let's provide an example. I think we need to kind of understand what do we mean? Someone's working and getting paid their regular normal rate of pay, which is above minimum wage, for a number of hours less than 40. And then they work a number of hours. Let's just say they normally work 35, and this week they work 37. The question is, am I owed 2 hours of pay according to the Fair Labor Standards Act? Yeah?
Yeah, and I think that so it would basically be that person worked 2 hours off the clock.
Okay.
And so they didn't clock in for it. And what the Fair Labor Standards Act says is they must be paid the minimum wage for every hour worked up to 40 in a work week. And so because these 2 extra hours that the person worked did not take them below the minimum wage for the 37 hours that they worked in this particular week, the employer doesn't owe them for that money, at least not under the Fair Labor Standards Act.
Because
and that's what the gap
their
time
average hours, their average rate of pay for the number of total hours worked, whether compensated or not, still exceeds the federal minimum wage.
Correct, which is currently $7.25.
All right. So that I can get my head around. Now, what happens if that gap time, same thing. I work 35 hours. I'm paid for 35. I now work 42 hours.
Mhm.
So I'm now working over 40 hours, and I know then there is Fair Labor Standard says time and a half must be paid.
Yeah, well, and that gets a little more complicated because what the Fair Labor Standards Act actually says is that the person must be paid time and a half their regular rate of pay for all hours worked in excess of 40 in the work week. And so then that becomes a question of what is their regular rate of pay? Is their regular rate of pay,
Mhm.
let's say, for example, this person's making $15 an hour as their regular rate of pay, and they're supposed to make that for every hour up to 40 hours in the work week. Or is it the $15 an hour times the number of hours they worked in the work week, whether it's 35, 40, or 45. And then you have to do the math to see what their regular rate of pay would be per hour. And then they'd be entitled to time and a half their regular rate of pay. And what I think this decision really says is that the individual is entitled to time and a half just their regular rate of pay, the $15 an hour. You don't have
I
to
hope
do
it. I hope that's what it says because that makes it a lot easier on
it
us.
does,
Yeah, versus trying to figure out any gap hours missed, which sometimes will be debatable because there's no record
right?
in that case.
Yeah, and I think that the court really focused heavily on the statutory text of the Fair Labor Standards Act.
Mhm.
The judges said Congress created remedies for minimum wage violations and overtime violations. They did not create a separate remedy for unpaid straight time hours that fall within a work week where overtime also occurred. Okay, so they're not going to get they're not going to get paid straight time hours for this gap. Now, if they
Okay.
do work overtime in that week, they're entitled to time and a half their regular rate of pay for all hours worked in excess of 40 in the work week. But the regular rate of pay is going to be that regular rate of pay that was set in our example that we've been using. That's $15 an hour. So the court
Right.
was really unwilling to read additional obligations into the statute.
Hmm. Very interesting.
Mhm.
So, one of the things that kind of catches my eye in this was the court's rejecting of the long-standing
Yeah.
Department of Labor guidance. Why is that important here?
Well, again, like I said, for years, and I'd even go further than that and say, I mean, I've been practicing law over 30 years now. So literally, I think for decades, as far back as I can remember, the Department of Labor has maintained that overtime isn't properly paid unless all straight time compensation is paid first. And the court reviewed that guidance and found it unpersuasive. And that's very important because it shows that courts may be less willing to defer to agency interpretations that go beyond the text
Hmm.
of the law, which gets us back to how we started, which was the Chevron deference, the Chevron case that we've talked about repeatedly on the show.
Yeah. So right away, I'm thinking there's probably somebody out there going, "Oh, good. Now, now because I pay much higher than the federal minimum wage, I don't have to worry about this any longer in the way that I once did to be accurate on my pay records."
Yeah, so I think that that would not be the correct attitude to take. First of
Yeah.
all, we have to keep in mind that because many state laws require much more than the federal minimum wage,
Hmm.
you have to still really pay attention to this issue because you might have an issue under state law. Also, employers can still face a significant liability for record keeping failures. I've said many times before that under the Fair Labor Standards Act, it's one of the one of the few areas of the law where the employer is sort of guilty until proven innocent. And what I mean by that is the Fair Labor Standards Act itself creates an affirmative burden on the employers to keep and maintain accurate records. And so if you don't have the accurate records to defend one of these cases, you may end up prevailing on the underlying case, but you might get nailed for record keeping failures. There also is the whole issue of meal break issues, overtime calculation errors, and exemption classification disputes. So you're not out of the woods yet, but it is something that employers should consider, this gap time issue as they move forward with their pay practices.
So let's just talk a little bit more about record keeping, because that's really what this whole thing is based on, right? Is the record keeping hour. And the court did hold several findings based largely on employee testimony. What should employers take from that?
Yeah, so if your records are weak, someone else's testimony who may not have their interests aligned with the interests of the business may become the evidence in the case. And we may not be with a manager or supervisor who can refute that evidence. So the court reinforced that a relatively small group of employee witnesses can be used to establish broader patterns affecting thousands of workers in this class and collective arena.
Yeah, that seems a little surprising to many employers. Only a handful of employees testified, yet the case affected thousands.
That's right. And we saw what the liability was that was associated with that when we started talking at the beginning of discussing this case, that in this particular Third Circuit case, it affected, like I said, nearly 6,000 employees and had resulted in a damages award exceeding $35 million.
It's a lot of money.
It is.
On the voice of a few, right?
Yes.
So employers also had another victory, if you look at it from the position of the employer, involving exempt classifications. What can you tell us about that?
Yeah, so historically, many courts have applied a very employer-friendly, an employer-unfriendly standard, saying exemptions must be construed narrowly. And the Third Circuit said that that's outdated. Employers must prove exemptions by a preponderance of the evidence standard, and courts should give exemptions a fair reading. Preponderance of the evidence means more likely than not. So think of 50.1%, more likely than not. And so an employer unfriendly standard would be requiring the employer to prove it at a much higher rate, like maybe beyond a reasonable doubt or something like that, or a higher standard that's much higher than the preponderance of the evidence.
So for our leaders who are listening today, what are the practical steps that they should be taking away right now?
Well, kind of the same as we've always recommended, which are you should routinely audit your timekeeping systems and policies. You should review meal break practices. The one we've talked about most frequently on the program is when a company has automatic meal deductions, where the timekeeping system automatically deducts a half hour every day for employees' lunches, but we don't yet have a witness who can walk in and say, oh yeah, this employee was completely relieved of duty, or they were able to use the lunch or meal period predominantly for their own benefit, depending on where you live. Those are the two tests. And so that's the classic example, and you want to make sure that your timekeeping systems are not automatically deducting for meals. You always have to verify overtime calculations, reevaluate exemption classifications, and definitely strengthen manager training on the FLSA.
Yeah, I like the example that you traditionally give. I thought you were going to go there. You know, if you're working in a retail store and it's just you in the retail store, which is not unusual in a small retail store, and you think you're taking your break, you're sitting behind the counter, you hear the door bell gives an alarm or a notice that you have a guest, and you're 5 minutes into your 30-minute unpaid break, and then you go serve the customer. And that's what every employer would want, is serve the customer. But at that point, if you're deducting that 30 minutes, that creates a big risk.
That's exactly right. That's why those automatic meal deductions are so problematic.
Yeah. And if anyone needs help in that audit process, that's exactly what AIM helps organizations do. It's probably a good idea, Burt. I'm just going to guess, do something like that, maybe under the directive of your attorney.
For sure. You definitely want to do these payroll audits under the guise of attorney-client privilege, and whether that's enlisting somebody like me to sort of retain an entity like AIM to do the audit, you definitely want to make sure that those are cloaked with attorney-client privilege. You don't want the results of your audit to become public or publicly disclosed.
Yeah. Do you expect any additional litigation in this area now? With this is kind of a new thing for us.
Yeah, no, I think that the Third Circuit decision that covers Pennsylvania, New Jersey, Delaware, and the Virgin Islands. The Third Circuit ruled, if I recall correctly, very similarly to the Second Circuit. There are some other circuits that have reached different conclusions. And so I think as long as there's a split in the circuits, you're going to see continued litigation in this area until the U.S. Supreme Court resolves the issue. And I think I know which way the Supreme Court's going to go on this in light of their Chevron
Mhm.
ruling from a year or two ago. But yeah, I think that litigation in this area is definitely not going away anytime soon.
Yeah, when I think about it from a 30,000 foot view, there's a lot to look at here. What's the biggest lesson from your point of view?
Um, yeah, I guess what I would say, Phil, is that wage and hour compliance remains one of the highest risk areas for employers. Winning one legal argument doesn't erase risk created by poor practices, weak documentation, inaccurate records, or misclassification decisions. And so again, I think that you're going to continue to see these types of cases being brought over time.
Yeah, yeah. All right, Bert, do me a favor, wrap it up with three takeaways for our listeners here.
So the first one would be that the Third Circuit rejected the overtime gap time claims under the FLSA. So that's the first one. Second one is strong record keeping remains one of the best defenses available to employers. And the third one, of course, is something I've recommended quite for decades, is that employers should continue auditing their pay practices because wage and hour litigation remains highly active.
Yeah, and I know I recommend to employers often when we do outsourcing work and things with it. It's something we want to look at because it's kind of hidden and it's off the radar. It's not something we all think about every day. As a reminder, it's a good idea to do that on some level of frequency. Do it under the directive and confidentiality of your attorney. If you like what you're hearing and you understand you need some help in that space, contact Burt. You can reach him at burton.garland at ogletree.com, and he'll be happy to engage AIM or another service to help you do that, or even do it yourself if you choose, but at least you get some of the protections that you need. I think that's probably the best advice to give is it is time to take a look at this if you haven't done it in the last couple of years and just make sure that we're doing all the right things. If you like today's episode and you value the discussion that we had, please subscribe to our YouTube channel. We always appreciate that. Share it with a colleague. We are on a mission to help every employer, particularly in Missouri, Illinois, Indiana, and Florida, and visit our AIM page at AIM. That's AAIMEA.org for additional resources and training and expert guidance. All right. Now, last thing is let's go out and be good to someone. Take care. Bye bye.